So, good morning, ladies and gentlemen, dear friends. Welcome to a new academic debate organized by the EBI. It is with great pleasure today that we'll have the opportunity to discuss on an extremely interesting, valuable book that was published last year. The co-editors were Diane Fromage, a dear colleague who is professor at the University of Salzburg. She's closely associated with the EBI as well. And the second co-editor is a dear friend, Raffaele D'Ambrosio, Banca d'Italia. And they managed to produce an extremely interesting work with conceptual parts, but also with national examples of how the resolution frameworks work at national level. And since the title of the book was The Role of National Resolution Authorities, how these national resolution authorities were set up, how they are operating, and mainly to draw conclusions on whether and to what extent there are differences between these national resolution authorities. And Diane kindly asked me whether we can, and Raffaele, whether we can make a kind of presentation of the book, and here we are. And we have the great pleasure to have with us to discuss on this book with three very good friends, and two of them dear colleagues, with Seraina Grunewald. Thank you very much, Seraina, for being with us. With Filippo Annunziata. Hello, Filippo. And last but not least, Eleftheria, who is Diamanti, who is the legal counsel of the Single Resolution Board, which is another resolution authority, but not a national one, a supranational. So, taking this into consideration, I think I need to stop it here. Thank you all very much for having accepted to participate. I very much hope that you, the audience, we have already 50 people attending, which I consider is a very good turnover, and more may join. And I give directly, Diane, the floor to you. Diane, we cannot hear you. You are muted.
Okay, now it works. Apologies for that. And I also was trying to share my slides. Is that working? Yes. Okay. Thank you so much. And no, thank you very much indeed for the invitation and for the opportunity to present this Quaderno di ricerca giuridica. So this is a publication that has been published by the Bank of Italy, and it's a long-standing project for which I'm very grateful to my co-editor, Raffaele D'Ambrosio, but also to Christos for the opportunity to present today, and also to all that have been involved. I know that some of the authors from the national authorities, from academia, but also from the SRB, the EBA, and the ECB are present today, so thank you so much for this. And basically, as Christos was saying, what we aimed at doing with this publication was to look at how member states have organized from several perspectives their national resolution authorities, and also what is the role of the EU institutions and bodies that I've just mentioned in monitoring those institutional arrangements or in influencing them, etc. So with this in mind, I would like to briefly share with you the main findings of this research project. And I will first start by outlining a little bit how the project came about and what our precise main objectives were. Then I will present the main findings, as I was saying, and then later on I will turn to some conclusions of the study and also perhaps going forward. So this is the publication, and we had 40 contributors. We were very fortunate to have 40 colleagues from academia and practice, I've mentioned. So we had contributors from various resolution authorities, but also central banks, where those are separate, that were involved in the project, and EBA, ECB, and SRB. And the main idea, or the starting point that I took for this study, was to say, well, we have Article 3 BRRD that says that member states were required at the time, because many of them did not have resolution authorities when a resolution started to be enshrined in a mechanism at the EU level. So they were required to designate one or more resolution authorities, empowered to apply the resolution tools and exercise the resolution powers. And they may be national central banks, competent ministries, or other public administrative authorities, or authorities entrusted with public administrative powers according to Article 3, provided that the choice falls to a public administrative authority or an authority endowed with public administrative powers. So this is what Article 3 says, and what we had as a sort of research question for this study was to say, well, how is it that the member states have implemented this obligation that is set upon them? And how is the relationship between various authorities organized, where the central bank, for instance, plays this role, or where we have several authorities that play the role of the national authority? So this was what we started off with. And what we thought was interesting to highlight was the fact that basically the EU legal framework foresees that only in exceptional circumstances can the functions of the National Resolution Authority and the function of the National Competent Authority, so the supervisory function, be entrusted to the same authority. However, if we look at practice, basically in most cases, in most member states, it's still the same authority that exercises both powers. So on the one hand, we have this provision that foresees that this may exceptionally be the case, and on the other hand, practice does not mirror this at all. We also considered the fact that Article 3 of the BRRD foresaw that there should be adequate structural arrangements in place to ensure operational independence and avoid conflicts of interest between the functions of supervision or other functions of the relevant authority and the functions of resolution authorities pursuant to the BRRD. And that member states are required to ensure that within the competent authorities, national central banks, competent ministries, or other authorities are operationally independent, so that there should be operational independence between the resolution of function or the supervisory function and other functions that the same authority may exercise. Because what we witnessed with this study is the fact that we have a concentration of functions, not only between supervision and resolution, but also on occasions other functions. So along the lines that the Article 3 BRRD foresees, we had a questionnaire that was circulated to all our 40 authors. It may also be found at the end of the publication. And basically, we looked at 4 different or main themes. The first one being institutional arrangements. The second one being the question of independence. So how independence is guaranteed and what is meant by independence. Then we had questions related to accountability, and notably the role of parliaments, for instance, in how the various members of those national resolution authorities are nominated, and then we had the questions of liability and sometimes distinction of liability regime between the national resolution authority and other functions that may be exercised. And now moving on to the main findings of the study. So we found that, as I was saying at the beginning, although the Article 3 BRD foresees that only in exceptional circumstances there would be a concentration of function between supervisory authority and resolution authority, well, basically we see that a lot of the resolution authorities established in the member states are in the central bank. So that's the case for 15 of them. Then we have the case where the resolution authority and the national supervisory authority are in a separate institution, so an institution that's separate from the central bank but still together. And only in 6 cases do we have a resolution authority that is completely separate and independent. So we see here a centralization of functions in favor of central banks. And we also witnessed that this is a trend that is growing. So we had recent reforms that go in this direction. That's notably the case of Latvia, where basically the central bank was empowered at a later stage with the resolution function as well. Then we also considered first, why is it that what was the trigger for the creation of resolution authorities? And of course, an important trigger was the introduction of the BRD, but another trigger that we found in some member states was the crisis measures. So as part of the response to the financial crisis that hit or started hitting Europe in 2008, on occasions there was a requirement to have a resolution authority in order to have access to financial means to go out of the crisis. So we see very much a coupling of trends in this direction. Another aspect that we thought was interesting to look at was the question of the legal basis. So where is it that the NRA is anchored at the national level? And here, as you can see on the table that's on my slides, we have an overwhelming majority of cases in which basically it's an act of parliament that is at the origin of the creation of the National Resolution Authority. Only in 5 cases do we have constitutional laws, and in 1 case only we have an executive decree that was later on ratified by an act of parliament. So in most of the member states we have acts of parliament. Then we also considered where the separation of functions, so between, for instance, central bank function and resolution function is anchored. And here we see really a great variety across the various member states. We also see a great variety as to how the internal organization is anchored. So on occasions we have separate organs. So for instance, in the French case, we have different colleges. One is in charge of supervision, the other one is in charge of resolution. So we can have separate organs with separate lines of management, or different vice governors or council members that are in charge to ensure this separation of function, which, as I mentioned before, is a requirement under EU law. And we witnessed, based on the answers to the questionnaire that we received, that overall, despite the separation of functions, the exchange of information between the supervisory authority and the resolution authority functions rather well. So we have, we do not see any issue despite the existing separation.
Yeah, Jan, may I interrupt you? There is a question whether we can put the presentation in full screen mode. Is that possible?
Okay, yes.
It would indeed help. Thank you. Thank you very much.
Yes, apologies for that.
No. Yeah.
Then we have the question of independence. And here, what we witness is that basically it's not a clear requirement in the BRD. At the same time, there is an important mention in favor of independence in the FSB key attributes. And here, the hypothesis that we formulated was whether the fact that the BRD does not mention independence specifically is because of the need for closeness with the government in case of a banking crisis. And in any case, what of course matters is the question of independence from the other functions, as I mentioned at the very beginning of this presentation. And in this respect, we looked at functional, personal, and financial independence with the interesting cases, for instance, of Austria and Germany, in particular in Germany with the link to the ministry. And here, as I mentioned before, we also looked at ECB, SRB, and EBA and their relationship to these arrangements. And we thought that it was interesting to look at the role of the SRB, because at the end of the day, of course, this is of crucial importance for the SRB that the NRA functions appropriately if there is a resolution. And we therefore considered its role, and we saw that the SRB is responsible for the effective and consistent functioning of the SRM. And the question that then arose in this respect was whether it could demand functional independence. And so far, the attitude of the SRB has been to be very cautious in this respect. Then we considered the question of accountability and liability. And we found that basically democratic accountability can take various forms. It can be direct, so for instance, in relationships between the NRA directly and Parliament, or indirect. And it's quite varied. Then we looked at the question of administrative accountability. So what is the role of Court of Auditors and also other forms of audits that may exist in some of the member states. And we found that there are limitations of liability that exist in some member states, but not certainly in all of them. Coming now to my conclusions. Basically, what we found is that even if we observe some common features across member states, we do see a large variety, and that's probably because of the question of national constitutional identity and the fact that also to save resources, NRAs were created in pre-existing institutions, and notably national central banks. We also found that arrangements to ensure the separation of functions indeed exist, but they can be sometimes too strict, unduly complex, and costly. And there we rose a little bit the question whether such a strong separation is necessary in the first place between the supervisory and the resolution functions, where both are two sides of the same coin, so to say. So that's a little bit the question that we posed. We also witnessed that depending on the member state, the level of independence from the political actors can vary from strict to less strict, depending on the member state. We found as well that the possibility for EU institutions and bodies, so our three institutions, ECB, SRB, and EBA, in their possibility to check and influence the institutional setup of NRAs is rather limited. So there is a strong dependence on the European Commission and its ability or willingness to launch an infringement procedure if there would be some issues. And there we also asked the questions whether it would have been possible to go further in terms of the requirements of accountability and liability, potentially without encroaching upon the duty to respect national constitutional identities. And here are my final words. We also considered how these arrangements at national level can be compared or not to what we have at the European level. And essentially our conclusion was that we see at the national level a concentration of functions. I've said that on several occasions, whereas at the EU level we have, well, the ECB on the one hand and the SRB on the other, and we have, well, a very clear separation. And we found, or we at least posed the question of this highly fragmented EU framework, which leads to very many complexities in the area of resolution, and therefore and relatedly to also some readability issues. So maybe there is some food for thought and some lessons that can be drawn from the national experiences. Thank you very much.
Thank you very much, dear Diane. Very clear, excellent overview. I understand the guidance that you have given at the beginning gave the opportunity for a comparative and duly structured contents of the book. There are so many issues here, and I think I have read the book, most parts of that, even commented on some articles. They are excellent. I have one specific issue that I would like to raise, but not for the time being. So we continue with our dear friends who are here to comment on what they have heard and what they have read. And let me start with you, Eleftheria. Yeah, if you allow me, unless there is a strong opposition on this, because the SRB is kind of, is not the supervisor of the resolution authorities. Yeah, it is just simply responsible for coordinating the way that this system works. Yeah, for the sake of the optimal operation of the SRB. So of the SRM, I'm sorry. So, Eleftheria, thank you for joining us, and you have the floor.
Many thanks, Christos. Many thanks to all for the invitation to this academic debate. I'm very grateful for the opportunity to discuss the pertinent topics raised by this comparative study, which was coordinated by Diane, but also by a dear colleague, Raffaele. Let me start first with the usual disclaimer that the views expressed today are solely my personal views and in no way represent or refer to the Single Resolution Board with which I'm affiliated. And now I can go to the main part of my presentation. So I would like to highlight three actually elements. I will start with the relevance of the topics raised by this study for the SRM. I will then continue with the relevance across the EU banking resolution, focusing in particular on the aspect of operational independence that was also mentioned by Diane. But then I would like also to highlight how the same topics can be relevant for other sectors beyond the banking resolution. Let me now start with the SRM angle. I would like to start first by briefly highlighting the role of the NRAs within the SRM. This role varies depending on whether the entity falls under their direct responsibility or whether the entity falls under the SRB's direct responsibility, but in both cases, their role remains central. As we know, for the entities that they fall under the NRA's responsibility, that they're mainly directly responsible for LSI entities, groups, to the extent that they do not qualify as other cross-border groups. The NRAs, they adopt all of the resolution-related decisions at the stage of the resolution planning, but also in case of crisis. These decisions are subject to the oversight function of the SRB in accordance with Article 31 SRMR. And what does this mean in practical terms is that it means that the NRA informs the SRB about its draft decisions, and the SRB may express its views, in particular as to whether such decisions are in line with the framework and in particular with the SRMR. At the same time, the NRAs, they have a key role also regarding the entities that are falling under the SRB's direct responsibility, since NRA staff are crucial members of the internal resolution teams, the teams composed by the SRB and the NRA staff in preparing all the relevant assessments, but also NRA representatives are members of the executive session of the SRB adopting the decisions concerning specific banks. Finally, all NRA representatives are members of the SRB's plenary session. So, and apart from the tasks listed in Article 50 SRMR, the plenary session has a key role in the development of the policies of the SRB, which means that when such policies are developed, the NRAs are consulted and their comments are taken into account. So in this way, NRAs support also the SRB in ensuring the effective and consistent functioning of the SRM. So I did this small introduction just to illustrate the high degree of interconnectedness between the authorities within the single resolution mechanism, and to show that effective cooperation within the mechanism and actually the efficient use of our resources in pursuit of our shared objectives presupposes that we have a proper understanding of the diversity that characterizes the system. So this is for me precisely what the study succeeds in capturing. What the study demonstrates is the diversity of the approaches taken when setting up the resolution authorities within the EU, and the structure, the institutional arrangements, and the size of these authorities, as Diana said, can vary widely from one member state to another. And in some member states, they are rather large authorities. In other cases, they are small. They are within they can be more than one resolution authorities. And as Diana showed very nicely in the diagram, they can be situated in the national central banks within the same authority as the supervisor, but in some minority, they can be also standalone. So with this, I would like to pass from the relevance from the SRM more to the relevance for the whole bank resolution across the EU. And I would like to focus on this topic, which is heavily discussed within the study due to the coexistence of the supervisor and the resolution authority within the same authority in the vast majority of the member states. This is actually the topic of operational independence of the resolution function from all the other functions, and in particular of the one of the supervisory authority. So what the EU legislator did is that the legislator did not prescribe a specific model as regards the institutional arrangements, and this was because the intention was to respect the differences of the constitutional and administrative systems. What instead the legislator did is that in Article 3, Paragraph 3, as also Diane mentioned, is that the member states, it obliges the member states to ensure the operational independence and the avoidance of conflicts of interest. I would like to note that during the delivery of the different contributions for the study, we did not have any judgment of the court at that moment. But immediately after the delivery of the contributions, it is very important to note that the Court of Justice provided its guidance on the interpretation of this provision in the Getting Noble case. So it is the case C118/23 regarding the resolution of the Getting Noble Bank by BFG, the Polish Resolution Authority. In that case, the BFG was not only the resolution authority, but it was also tasked as a temporary administrator of the Getting Noble within the meaning of Article 29 BRD, and also had some DGS functions. So it's very interesting to see what the court noted in this particular case. So first of all, the court started by the objective of this provision, and it highlighted that this provision concerns the risk of decision-making distortion when an entity performs multiple functions, and intends to protect the decision-making of the resolution authority from any influence which is external to the resolution tasks and the purpose to achieve the resolution objectives. The court concluded that this article applies also in cases where the authority performs temporary administrator or DGS functions, and this was based on the fact, on the broad wording of Article 3, Paragraph 3, and in particular that in specific circumstances, okay, for temporary administrator it's quite obvious why there can be this conflict, but also for DGS functions, while the objectives are to a great extent aligned, there might be circumstances, for example, cases where the national resolution sites, in this case the BFG, might need to compensate the DGS in case of further losses, etc., in case of, for example, of use the DGS in resolution. So with this in mind, the court concluded that Article 3, Paragraph 3 applies. For me, the most important guidance of the court was about the operational aspect, because the court explained what operational independence means in concrete terms. First and foremost, the court noted that separate organizational structure does not mean that the authority needs to have a separate decision-making body when it acts as a resolution authority. So convergence can there can be convergence at the high management, at the high level management of the authority. Another important element which has a big impact on the functioning of the authorities is that the court gave the reassurance that internal functional areas such as the legal department, the HR department, or the IT departments, they can provide support services both to the staff assigned to resolution functions, but also to the staff assigned to other functions. And finally, the court also highlighted, Article 3, Paragraph 3 says that the member states or the resolution authority, they need to have internal rules operationalizing this structural separation, and they need also to publish them. And the court said that internal rules can mean also organizational measures that they have in place and other measures they have in place if these are described, with sufficient precision. And the final element, which is also very important, is that there is no need that, of course, the framework says that you need to publish, but if you don't publish these internal rules, this does not affect the validity of the resolution authority's decision, but it's then for the resolution authority to establish that these internal rules were actually complied with. So for me, this judgment really brings further clarity to one of the key topics discussed in the study. So and now it's very nice to look at this overview, with these fresh eyes and under considering the guidance of the court. Finally, I would like to highlight now that the topics also identified in the study, it's focused on the banking resolution, but at the end of the day, they are relevant not only within the scope of the BRD, but the same topics arise and some conclusions may be considered also relevant for resolution beyond the banking sector, meaning under the recovery and resolution regulation for central counterparties, regulation 2021/23, but also under the more recent insurance recovery and resolution directive, which, if I remember correctly, is to be transposed by the member states by January next year. And now just to give an example, the wording in Article 3 of the BRD, which deals with all the elements that the study discusses, institutional arrangements, operational independence, the relationships with the relevant ministry, or potential limitation of ability, is actually to a great extent the basis for the relevant articles in the CCP resolution regulation and in the IRD. However, what the wording of CCP resolution regulation and IRD they do is actually probably built on the experience of the BRD transposition and functioning, and they provide further practical clarifications as regards some aspects. For example, for the topic of operational independence that we discussed also before, in light also of the Getting Noble judgment, the CCP regulation and the IRD, they go a step further. And first of all, they do not include this exceptionally, that they should be exceptionally in the same authority. I think this is left out of the text, but they also clarify that the requirement for separate organizational structure does not prevent, first of all, reporting lines to converge at the highest or senior management level of the authority performing the different functions, but also it doesn't prevent staff to be served under predefined condition to deal with temporarily high workload, or to be able also for the resolution authority to avail itself of expertise of shared staff. And I think these are definitely some improvements and of the framework, but they go, towards a very efficient functioning of the authorities. That, of course, they are welcome. But it also shows that some elements can be common across sectors. So let me conclude, and I'm happy, to discuss also with you other topics. So for me, what this study does is particularly valuable, not because it maps only the diversity of the national institutional arrangements. For me, it is also valuable because what it does actually for me, it provides reflection on how this diversity can be accommodated. And while we will need to still ensure resolution frameworks that they are effective and credible. Thank you very much for your attention.
Thank you very much, dear Eleftheria, for your insightful remarks. I particularly appreciate your last comments on these cross-sectoral issues. We have just, as I mentioned to you before, we have just launched an initiative at the University of Luxembourg to discuss this in depth. I mean, to see what are the differences between the resolution regimes and the role of resolution authorities in the 4 systems that we have in the financial system, because we have 2 in the BRRD, one for credit institutions and one for investment firms, correct? Because the BRRD still applies to investment firms. We have another one in capital markets law, which is on the CCPs. And then we have the baby, the IRRD, the insurance recovery and resolution. And it's very interesting to see what are the differences, how they fit, what lessons can be learned from the most developed one, which is the BRRD type systems. So this is a very, very valuable point, and thank you for raising that. Seraina, I will not be so optimistic as to ask you to tell us about resolution authorities and resolution funding in Switzerland, because this would derail the whole discussion into the into the resolution of the resolution of the Credit Suisse case problem, not the resolution of Credit Suisse. Yeah, but we are glad you are here, and you may wish to give also some tone on differences between the setting in the European Union and eventually some missing elements, because there is a huge discussion now in Switzerland on what is missing. What lessons could be learned from the European framework for Switzerland, even if you don't want to mention it as such? Yeah.
Well, thanks a lot. Yes. First of all, thank you for having me here today in this interesting debate. Very happy to be contributing. And first of all, of course, a big congratulations to Diana and Raffaele and all the authors of this amazing study of more than 700 pages that we had, that we were lucky enough to read through. So, it was a great read. Thanks a lot for that. I think indeed the Credit Suisse case we have to postpone for yet another academic debate. Perhaps it continues to steer debate, of course. Interestingly, and that's the only thing I'm going to mention, is the only debate we are not having in Switzerland is about the institutional setting. That's the only thing that we are not debating. We are debating reforms of our resolution framework. We are debating reforms of our supervisory framework, but we are not debating institutional reform. So that's perhaps an interesting remark at the outset. But now I'll focus on this interesting study, and I'll just share some very humble remarks from an academic perspective, following up on Eleftheria's really interesting points that she has already raised. So I'll center my comments around 3 points, and I will share a couple of slides here with you, if I manage to do that. And you will see, yes.
Great.
Is it working? Good, excellent. I will share remarks around 3 points, and you see that they're rather questions than answers. So hopefully we can have a debate afterwards on these questions. So the first point I would like to discuss is, why do institutional settings matter at all? And it's really sort of follows on what Eleftheria has already said. That this book, this study really provides super interesting insights into what is there currently within the SRM. Then I'd also like to zoom in a bit more on independence of resolution authorities. To what extent is it necessary? So let's discuss the the institutional criteria that may facilitate operational independence, but more focus on its rationale. And then as a last point, maybe more normatively framed, I will go a bit beyond of what the study does and raise the question, is there a superior model? Now, why do institutional settings matter? Now, of course, ideally, institutional settings are conducive to the objectives and tasks at hand. If in less ideal settings, they can prove to be an obstacle to these tasks. So what we are mostly concerned with, or what should interest us then, is what is the nature of the resolution task? Now, this is not big news to you. We deal in resolution with a high level of urgency. Authorities act under high time pressure. The task is extremely complex, it's extremely technical, so authorities need a large margin of discretion while, of course, remaining accountable to political and judicial authorities. Then the stakes are very high, so there is a high degree of credibility needed of the authorities' action, which points also to some extent sort of to a broad agreement among the authorities involved that the way forward is the right one. And then finally, of course, we deal with an area that is of high political sensitivity, because potentially state-backed financial support is involved, and also there might be the problem of national champions. So the study, Diane laid it out very nicely. It looks at different relevant variables: institutional arrangements, independence, accountability, and liability. And an issue or a point that she did not raise was, given the importance of the institutional setup for the successful fulfillment of the resolution task, the question actually, the study actually in its sort of conceptual parts raises the question, should then the member states be given such vast discretion in determining the institutional setup within, their local jurisdictions? Perhaps something we will come back to. Now let us zoom in on the independence of resolution authority, and clearly the BRRD, Diane laid it out, Article 3 requires operational independence from the supervisory and other functions, and what is central here is the avoidance of conflicts of interests. So, we probably are in relatively large agreement that some sort of operational independence of resolution authorities is required, and that there should not be conflicts of interest. But what are we actually talking about here? What kind of conflicts of interest could potentially arise here? If we look at supervisory authorities or supervisory tasks on the one hand, and resolution authorities, resolution tasks on the other. Now, you can think of different examples, right? I picked out two. One of them, certainly of big importance, at a point when the whole process is triggered, failing or likely to fail. That's the point that you should definitely not miss. So it is of huge importance. Now, what conflict of interest could arise there? You could ask yourself, and that was part of the discussion before the BRRD was enacted, supervisors could be inclined to forbear failing or likely to fail determination because, there might be the idea that the supervisor did not do its job good enough, and that's why the bank is now failing or likely to fail, and that's a situation the supervisor may want to avoid, right? So the BRRD probably to compensate for such a tendency, if it exists, allows member states to in addition, make the NRA competent to make the determination in lieu of the national competent authorities in national law. So I read, oh, the tendency most definitely exists. Thanks a lot. Good. That highlights, you know, my academic perspective is not entirely wrong. Good. So if we have an array that can, instead of the MCA, declare a bank failing or likely to fail, that could, you know, compensate for this tendency. Now, de facto, of course, it is very hard to imagine the situation where an NRA would move forward, even though an MCA is very much against declaring a bank failing or likely to fail. So open disagreement is de facto not really a possibility. If you look at litigation that has been happening, it's often around failing or likely to fail. Clearly, claimants would have a very good point when they said, well, the supervisor was against it. It was only the resolution authority thinking our bank was failing or likely to fail. Good. So that's example number one. Example number two, you know, that where you could imagine that there could be a potential conflict of interest is the assessment of a potential buyer in a sale of business transaction. You could imagine that the National Resolution Authority may be inclined to say, okay, we have a buyer, you know, we have a buyer on the resolution where we can, so let's go through with it. We have a solution here. And then at the same time, the national competent authority may say, well, but, you know, we do have some concerns. We do not think that this transaction should go through. So this could be another potential conflict of interest where you could say Chinese wall between these two functions would definitely make sense. Now, moving on, independence from finance ministries and governments. That is a question that comes up in the study. And there appears to be, at least in the conceptual parts, there appears to be the understanding that, oh, well, you know, here there is a difference between the resolution authority and the supervisory authority in terms of how far this independence can go. And I tend to agree with that, especially, and that's clearly, you know, we see it in resolution cases that have involved any forms of funding, right? It will be very hard for a resolution authority to act independently of political actors. I'm moving to my third point. Is there a superior model? And again, that is not something that the book claims, and I think it rightly doesn't do that. You know, we've had 10 years of SRM. It's the right moment to take stock of the different models that are practiced out there, but it's too early to really come to a conclusion as to whether there is a superior model or not. Now, I was reminded, nevertheless, of a similar debate that we had in the 2000s about whether banking supervision should be conducted by the central bank or through a separate agency. And there has been some back and forth there as well. You may remember originally the UK had a financial services authority, and then it did become you know, part of the Bank of England through the Prudential Regulation Authority after the global financial crisis. However, at least the literature that I know has never really found clear evidence for the superiority of either model, right? It's, you know, these models, they grow largely organically. They're influenced more by historical, cultural, and constitutional aspects rather than really be you know, that they're set out on the drawing board and then, you know, with a strong sort of normative idea behind. Now, one last point that I would like to make is that even though institutional setting matters a lot, separation between functions matter, accountability matters, operational independence matters. But what also matters is what I call institutional capacity. And the Article 3, paragraph 8 of the BRRD actually mentions that too, right? Member states must ensure that resolution authorities have the expertise, the resources, and the operational capacity to apply resolution actions. And they must be able to exercise their powers with the speed and the flexibility that are necessary to achieve the resolution objectives. I think that is really central here. And with that, I think where we are at is united in diversity, very diverse institutional settings, but united in the objective that we pursue, maintaining financial stability through resolution action. And with that, I hand over back to you, Christos. Thank you.
Thank you very much for this insightful information and presentation, dear Seraina. Just a few brief comments before I give over to Filippo on the first issue that you mentioned on the Swiss case. Yeah, this institutional aspect would be discussed, in my view, and you know much better. Yeah. When discussing on the powers of the FINMA, yeah, in relation to early intervention. So the operational independence of the FINMA, yeah, could be further enhanced not only in relation to early intervention, which is more of a supervisory tool, yeah, but also in relation to the way they would be implementing their resolution actions. You know better how this discussion can go on. Coming to slide number 4 of your presentation, you are absolutely correct. There are some cases where you cannot really say under European law what is the balance between the role of NRAs and NCAs, and this may be even worse, and it has been shown in some papers. I have seen that of Christos, Manuel, yeah, when the two are in the same family, yeah, when you have the NCA and the NRA in the central bank, for example, in Greece, yeah, the situation becomes worse. And it becomes even worse, as you mentioned before, on the point you raised before, when, in my view at least, the understanding of the trigger, the first trigger, and correct me here, anyone, if I'm wrong, that the determination of a bank as failing or likely to fail is a supervisory determination, which must be made first by the supervisor. At least this is the way that the court has decided, yeah? And the role of the NRA is a kind of a supplementary. It can confirm the decision, but according to the court, yeah, it's a purely supervisory decision, in my view, correctly so, because they follow the SREP. Yeah. So there are some gray areas which are very, very interesting, and thank you very much for having highlighted them. We can come back to this later on. Filippo, welcome to our group. Looking forward to your valuable, brilliant remarks as always.
There's not much to say, so I will actually talk about something that is not directly addressed by this great book, which is the appeal panel at the EU level. Okay, so apart from having read not all of it, but most of the book, and it's really a great achievement. Everybody knows, or most of you know, how much I'm concerned with comparative law, comparing systems and models. And when I saw that thing coming out, I said, wow, this is what we should do in all areas of EU financial regulation, not just the resolution authorities. We need more comparison. We have to look at how models have been construed, how they have evolved, and comparing them. So congratulations, Diane and Raffaele, for what you did. But then I said, okay, what am I going to talk about? I don't seem to be able to share my slides, but it's not a problem. I will, in any case, follow them as I talk, and then I will make them available at the end. So I thought I would focus on the Board of Appeal, which is a unique feature actually of the SRB at the EU level, and it's an example, it's a model of how you could sort of structure judicial review or some kind of a judicial review in resolution authorities. So I won't be able to answer the final question whether this is a model that ought to be followed everywhere. But I want to raise the issue and see whether it is something that we might consider of adopting at national level, where an appeal panel does not exist, and whether we still go to court directly when we have to challenge a decision by a resolution authority. And naturally, this also calls into account what happens with supervisory authorities, not just banking authorities, but also capital markets authority. So is it a model? Is it an exception? Is it something that history will forget as an anomaly in the setup of broadly speaking supervisory systems, or is it something different? So that's was what I was thinking about. And now, resolution law is particularly interesting because it is a laboratory, a very advanced laboratory for judicial protection. When a bank fails on a Sunday night and the Single Resolution Board adopts a resolution scheme in the early hours of Monday morning, virtually every aspect of EU administrative law is called into action. Proportionality, first of all, the right to be heard when these decisions are challenged, property rights, and broadly speaking, all the array of topics that we are struggling with in relation to judicial review. So it's really, the dream of any comparative lawyer. You find everything in there collapsing with a violence that doesn't always have the same effect when you look at other areas. For instance, the impact on property right that the resolution can have. Also in capital markets law, you do have impact on private law, but when you do have resolution and you start talking about the array of tools that you can use to resolve a bank, the impact on property rights is quite striking. So it's really a laboratory for judicial protection. And in 2014, the design was to set up this system of appeal through the Board of Appeal, which sort of worked quite a lot across over the past 10 years, maybe not as much as somebody is now suggesting, because the system came out, Article 85, Paragraph 3 of the SRM regulation, defines a relatively narrow catalogue of decisions that can be appealed at the appeal panel. So we have, for instance, contributions, we have fines, we have access to documents. Oh, let's not talk about access to documents because there's thousands of claims coming up, and certain procedural matters. Yeah, okay, quite significant, but the true resolution decisions themselves, the most consequential acts adopted by the board, are subject instead to judicial review, and they do not pass through the filter, let's call it like that, of the appeal panel. Is it right? Is it wrong? Some say that it's okay because otherwise we would turn the Board of Appeal into a monstrous creature that stands in between courts and administrative bodies. Some say that instead we should amplify the role of the Board of Appeal and of the appeal panel. And this argument also has an impact on what we are looking at, what may be the future evolution of the Board of Appeals of the three ESAs. And I'm not talking about the ABOR because that's a different animal. And we always say that the ABOR is a different animal. But after 10 years of experiencing the Board of Appeals, the appeal panel, are we really sure that we are entirely happy with the ABOR being such a different animal? Some say yes, but some say maybe no. Maybe we should look at this model and see if we can sort of move towards a higher level of convergence between the different appeal panels. It's a very delicate topic. I'm perfectly aware about that. But what I see in recent literature is that this topic is sort of coming up after 10 years. It is absolutely normal that we look at the different examples and we try to understand. So, so in 2014, limitation to this limited role of the appeal panel was understandable. Okay, resolution decisions are adopted under extreme time constraints. They involve a very complex endorsement process by the Commission and the Council. By the way, one of the most intricate, really casse-tête, they would say in France, right? C'est un système de casse-tête of the entire resolution mechanism, this intertwining and this very delicate balancing of powers and roles between the treaty, the Meroni doctrine, the agencies, the supervisors. It's fine, but again, after 10 years, this is a matter for discussion. And in this scheme, an additional administrative review layer could have threatened legal certainty in a highly time-sensitive context. But after 10 years, we can say that the appeal panel has done a lot of things, but ultimately in minor areas of the resolution, because the main decisions go directly to court. And then we have the central point, which is not unique to the appeal panel, but is relevant for all Board of Appeals, not just in the financial sector, the question of the standard of review. And now case law, most notably Acer versus Acquind and its subsequent refinements. This case law tells us that second-level appeal bodies should in principle conduct a full review rather than a limited review. And this is what seems to come out from the jurisprudence, especially from the Acquind. But is this always the case? I mean, should we look at these precedents as being valid for every Board of Appeal or Board of Review, regardless of how they are structured? Well, the arguments that the court raises in its case law as to the full review standard of the Board of Appeals is that if it were not a full standard of review, then the Court of Justice in itself would be limited in reviewing what has been filtered through the Board of Appeal or Board of Reviews. This is the argument. But if you look at this argument and you try to see whether it can be automatically transposed to the SRB, the answer to the question is less straightforward, because the Board of Appeal in the Acquind case operated under a model that I would call a model of functional continuity. And I'm also borrowing Marco Lamandini's expression in an op-ed weekend edition of a few days ago, functional continuity, because in that case, the Board of Appeal exercised powers that were comparable to those of the agency itself. But the SRB operates under a different model. It operates under what always Marco Lamandini calls a confirmation or remit model. And I do share this distinction, which is not subtle at all. It's very material. And so we can use the Acquind standard in the Acquind case, but is it really applicable to the Board of Appeal? And we do have doubts, because the Board of Appeal has a different mandate, so to say. It may confirm the decision or remit the case, but cannot substitute its own assessment to that of the single resolution board. So that is the point that makes the automatic sort of application of the standard of review after Acquind quite controversial if you look at the Board of Appeal, which raises reflection. So what is the best way looking forward? Should we amplify, should we modify the role of the Board of Appeal because we want really to be sure that the Acquind standard is applicable in this case as well, or should we maintain this distinction? I have no answer. I'm just setting out the question. I mean, I do have an answer, but I don't want to blow the bomb in the middle of the seminar. But I'm just raising the topic and just sort of realizing that these things are starting to be discussed. And the last point is the structure, or rather the independence of the appeal panel. And there are, first of all, differences in the way in which the appeal panel is appointed vis-a-vis the ESA's Board of Appeal, and this might be considered. Why are these differences still there? What is the process that leads to the appointment in the appeal panel? Some say, for instance, that the role of the Commission should be strengthened in order to reinforce the independence of the entire appointment process. But I don't know what the solution is, but again, there are slight differences that maybe we should take into account. But then there is the problem of what I would call the substantial independence of the appeal panel, which is resources, how the appeal is supported, how it is actually funded, and what is the kind of material independence that it can exercise. And if we go back to the last point that I was discussing, i.e., should we consider expanding the role of the appeal panel? Naturally, this question also has a very practical answer, which is okay. Financial, organizational, and structural independence, because this would have to be strengthened in some way. Now, to sum it up, if we look at the broad debate on Board of Appeals, Board of Reviews, not just in EU financial law, but in all areas of administrative law, there are some very ambitious proposals that somebody's putting on the table. For instance, let's try and sort of unify the different Board of Appeals, and let's put them together in a mega super Board of Appeal that would put everything together. And this is one thing. Another direction that is well known is move towards the quasi-judicial transformation of the Board of Appeals by making them more and more structured and turning them into something that would look more like administrative courts specialized in EU financial law. These have been on the table since a long time now. I don't think we have at the moment enough experience, even if 10 years are not 10 days, but not enough experience to decide whether this is the right way, and there are structural limitations, including those stemming from the treaty, obviously. But I just wanted to sort of remember that we do have these proposals coming up and up on a more regular basis. So just to close my intervention, is this something that really should be considered as sort of a model towards which national systems also should look at, or should we consider it as the anomaly in the 27 member states, because it's a regime in itself, and we sort of... Now, when Eleftheria was saying that there is a lot of interconnectedness in the resolution European scheme, it is perfectly right, but interconnectedness is complicated when you have too many diversity among national schemes. You talk with people, you have to dialogue with people and entities that have different schemes in their heads, and they have different models to share. And this is also a very well-known feature of supervision in capital markets. Supervisory authorities have a very different background. So united in diversity, yes, But maybe, and what I have learned, one of the many things I have learned from this great research by Diane is Raffaele, is that we have a lot of diversity. And it looks like truly, you know, Linnaeus catalog of animals and species, a zoological garden. And the last remark is, can we really manage all this diversity, interconnecting such diverse species that crawl on the territory of the European Union? Maybe yes, but maybe we should think of rationalizing a little bit the system. Thank you very much.
Thank you so much, dear Filippo. As always, not fruitful, but also entertaining the way you present it. Yeah. One comment here, which makes the situation more complicated than you have scheduled it. Yeah. Let's keep in mind that we have in the financial sector only 3 different appeal panels. Yeah. The appeal panel in the SRB, the Board of Appeal for the ESAs, and the Administrative Board of Review, the ABOR, for the SSM. An interesting issue is that when it comes to the ABOR, which is the appeal panel for an EU institution, has less powers than the 2 appeal panels, yeah, the one for the SRB and the one where we are sitting, yeah, for the ESAs, Filippo, which have more powers than the ABOR, however, less than you correctly said that they could have, yeah? And in this case, we are dealing with agencies. So from an institutional point of view, it's strange, yeah? For the one which is a EU institution, the appeal is less endowed, the appeal panel is less endowed than in the case of the agencies, yeah? A second point, apparently, is before we go into the holistic approach, whether it would be interesting to have one for the financial sector in global, yeah, to merge the 3 instead of merging all the agents, because we have appeal panels, I don't know how many, all over EU law. But in any case, the missing point here is that at the end of the day, and correct me if I'm wrong, and especially you, Diane, who have been, you know all the chapters, yeah, that when it comes to a national, the appeal panel is only for decisions taken by the SRB, correct? So when it comes to decisions of the NRAs, it depends on the national administrative procedural law, which provides or does not. In Greece, for example, it provides for a kind of a quasi-judicial review of the decisions taken by the national administrative authorities, ditto resolution authorities. Yeah. Okay, great. That was really very, very intensive introduction. Since I do not see any questions, may I raise the first 2 ones for all of you? Point number 1, coming to independence. We all know that the CRD4 has been amended in 2023 with the CRD6, yeah? And we have a new Article 4A for the independence of supervisory authorities. This week, we had a new set of rules for the BRRD, the SRMR, and we have nothing new on the independence of resolution authorities. Why that? First question. Second question, on a topic which is very much in my heart. Yeah, we had a book with Danny co-edited in 2022 on the liability of resolution and supervisory authorities. Yeah, a collective work at the OUP. And in that case, we realized that there are still a lot of different levels of liability regimes, yeah? And even at EU law level, we have different interpretations. Yeah, we have the Frankovitz liability standard, and then we have the Peter Paul case, and most importantly, the Kantarev case, yeah, which was the most recent one of 2018. And that was not for resolution authorities, it was for competent authorities in case of weak exercise of powers. So how is this discussion being reflected into the resolution authorities liability regime? This is a question in which in our book we didn't come to a conclusion because we didn't have a standard. Yeah, it seems like the different liability standards are being applied at different level in different jurisdictions. Yeah, so food for thought. Who wishes? Maybe Diane, we start with you. What is your reflection on these 2 points?
Yeah, no, thank you very much for the questions, Christos, and to all of you for great interventions. If I may, Christos, before I go to your comments, I would like to react on what Filippo was just saying about the boards of appeal, because I also wonder, Filippo, what is the role of the AMLA's ABOR? Because you were mentioning, the idea of merger, and of course, I think we all know that the ECB's ABOR will not be merged. What could happen perhaps is better information, or I think, that's here my wishful thinking that perhaps more information would be made available for the ABOR. But, to me, there is the new kid in town is the AMLA's ABOR, and what do we do with that? And how do we ensure that, this, because it's going to be overlapping with both this going on with the other boards of appeal. And to me, and that's perhaps also for discussion, it would seem that this is where we should have the merger. Now, the next question is, of course, that because it's an ABOR and it's not an appeal panel, it's not a first instance after the reform of the Court of Justice. So, but side notes, apologies, Christos, but I thought this was perhaps interesting for the discussion. Going back to your question of independence.
A third point for discussion. Let's go one by one, how you wish. Let's start with the last one. Why not? Filippo, would you briefly discuss on this and the others comment?
Yeah, well, we all know that the ABOR is a different animal, or at least has always been presented as a different animal for institutional reasons that we all share and agree. It's a long narrative. It's there since the beginning, but some problems remain. Okay, the first is access to the decisions of the ABOR. It's the only Board of Review Appeal that does not publish its decisions. There are reasons for that, but after 10 years, maybe we should think whether this is the optimum solution or not. I'm not necessarily in favor of one or the other, but it has its own reasons, but also its own limitations. As to the AMLA, I agree. What some say that the AMLA should be merged with all the others. I think that maybe even before we think about merging, we should think about why there are so many tiny differences when you look at these different bodies, one or the other. You have the impression, those games that you play when you have 2 or 3 pictures that look exactly the same, but then you have to spot the small difference. In picture 1, you have a cat sitting on a table with a tail pointing down. And in the other one, the tail is pointing up. And in the other one, it is oblique. But why is this? Are there really strong justifications? Because ultimately, this results in a different way, not just of how these bodies work, but in different levels of judicial protection. But do we really want to live with that even before we merge? Because if we merge, we have to find a standard. Okay, the point of arrival of a merger means that we have to find a common standard. If you merge them together, they have to work. they necessarily have to work in the same way. But why are these differences still there? Should we think about them and really ask ourselves whether they are truly necessary, even before we think about merging.
And let's think seriously what we are hoping for, yeah? Because when you know how much time it takes to deal with one case in the appeal panel or in the Board of Appeal or in the ABOR, yeah, if you merge them, you may end up in a situation you will not find people to sit in these boards. I'm serious about this, yeah, because it would become a full-time job, yeah. So it's also a very, very sensitive issue on how you structure these and how you make the selection process, yeah. We know very well how consuming it may be. So if you add them all and you have one case per month, yeah, those who would be selected would have a full-time job. They would have to quit anything else. So it's very delicate in that respect. Coming to the independence issue, Eleftheria, are you concerned about this imbalance that I mentioned before, that we have higher demand for independence for supervisory authorities and not for resolution authorities under EU law? Is this something that has been interesting for you?
It is not something that has concerned us, because in practical terms, I think all authorities, they have rules in place to ensure this independence. As to whether it would be appropriate to have something also at EU level, it could, but at this stage, at least, it doesn't raise a practical concern, given that the authorities are really mindful of this element. If I could take also, like, 3 minutes really to even to mention some elements that Filippo mentioned, because they can be the subject of a new academic debate. He raised a very particular point about, like, shall we expand the appeal panel also for the resolution decisions? Within the current institutional setup, and given that the SRB's decision is endorsed by the Commission, in light of the Meroni doctrine, I would find it impossible. So really, I leave it here. We could discuss for this like for much longer. Then I also agree with you and also with Marco Lamandini on this element of functional continuity and to what extent we can extrapolate elements from other case law for other. The wording of the legislation is completely different. And I would like really to briefly mention that also the Joint Board of Appeals, but also the SRB's appeal panel, they have expressed the view that they don't do a de novo evaluation, so that they respect the margin of appreciation of the authority and the decision-making process. So this might be also informed from the governance perspective, probably, that we know how the appeal panels are appointed. So, last point about can we extrapolate the appeal panel structure for national level? I do not have an answer. The reason I don't have an answer is a lot of these elements, they are influenced by the constitutional, even not only administrative law, but also by the constitutional one. So in order to make an assessment on this, it will need a really very broad consultation. Many thanks, really very interesting remarks.
Yeah. And even if it's not a constitutional issue, it's definitively administrative law. Yeah. Serena, any point on this independence and on the liability point that I raised? Do you have any answer here?
Christos, sorry.
Yes, I would like to give Raffaele the word. I've spoken.
Sorry,
is Raffaele with us? Yes, of course.
No. Sorry, I asked to give me the possibility to intervene, but only at
Raffaele.
the end. Hi, welcome. Thank you very much indeed. Just one point. Sorry if I interrupt you, but only because it's related to the last point on the appeal panel. Completely agree with Eleftheria on the reason why, but with a question on the reason why was not be possible to extend the competences of the appeal panel of the Single Resolution Board to resolution decision, because there is a Meroni problem, because decision of the Single Resolution Board are approved in between bracket by the Commission. The problem could be posed more but the problem is the decision on the ex ante contribution to the single resolution fund, because in that case these decisions are not included within the competence of the appeal panel, and here we do not have a Meroni problem. You know, the possibility to have a real appeal panel is provided for by Article 2063 for the decision of the agency and not for decision of the institution. The real exception here is AMLA, is the Board of Appeal of AMLA, it's the Administrative Board of Review of AMLA, because AMLA is an agency, but nevertheless the EU legislator did not the same solution as the one of the ESAS and the Single Resolution Board. Sorry for the interruption.
No. I take the opportunity and I leave then the floor to Seraina. Would you like to address the differences in the application of the liability standard across the member states on the basis of my comments before?
Christos, I don't think I can speak authoritatively to liability, but I can maybe take up the... Did you want to pass it to?
Please go on, and I will come back to Raffaele. Yeah, my question was actually to Raffaele, but please go on, Seraina.
Sorry, I thought. Okay, no,
go on. Yeah.
Just one point again on independence and the question of whether, you know, or why there was no mention of independence now in the most recent reform. I think the simple answer is probably that there was no need to do it in the sense that probably there was little agreement as to how far that independence should go on the one hand, and on the other hand little experience with to what extent this could even matter in terms of the different institutional settings. So I think this study delivers a very important insight in just how different the institutional settings are in the member state. It raises, however, the question, and I'm using now the metaphor of Filippo, does it matter really whether the tail of the cat points up or down, right? Because only if that matters for the cat really catching the bird in the end of the day, we should find a level of harmonization or a model sort of imposed from the top. If it doesn't matter, then, you know, let's be diverse. And I wonder really to what extent these differences that we see ultimately matter. I think that's for the next 10 years to be studied, and then we can sit here again and discuss. But now I pass the word back to Raffaele. Thank you.
Before that, Raffaele, one point, advocatus diaboli, Seraina. In the case of the supervisory authorities, it might a fortiori not be necessary, because most of them are the central banks, and the central banks are independent by the treaty. Yeah. So, food for thought. It goes both ways. Yeah. So it's a very interesting issue that they have put it in the CRD4. Yeah. And it applies only in the case that you have BaFin, for example, which is not the central bank. Yeah. While it would apply to Banca d'Italia because it is already independent, yeah, as an entire institution, does not apply to resolution authorities. But again, it was more for the discussion and less for because we can close it today. Raffaele, what about the liability issue?
let me say one word on the independence. It seems to me that the choice of the EU legislator with regard the independence, with regard the administrative feature of the resolution authority, is that to respect the constitutional and administrative tradition of member states. There should be a recital on the BRRD according to which this intention of the EU legislator is clearly written. The EU legislator didn't want to conflict with the constitutional and administrative tradition of member states. I think that the underlying reason lies on the importance and the relationship between the resolution decision and the public intervention in this field. So I don't know whether we could have a rule in the field of resolution similar to the one written in the CRD 6, but this is my point of view. With regard the liability, I just want first of all to remember that there is a rule on the liability of resolution authorities in Article 3 of the BRRD, and this rule pertain not only to the resolution authorities, but also to the supervisory authority, to the extent that supervisory authority act within the scope of the BRRD. For example, the early intervention measure. I think that this article refers to both, to all the field, the scope of the BRRD. With regard the liability regime, we have different liability regime in member states. As you know, we have three main models. No, the German one, no liability at all towards depositors. But common liability regime towards credit institution and financial intermediaries. Then we have the French model, limitation of liability to gross negligence, and not limitation at all, even though we should verify if the absence of a specific rule on liability means in de facto a no limitation of liability, because we should see the stance of the case law in this field. To be honest, I should perhaps see the most recent cases in each national jurisdiction, but as far as I know, the limitation, the cases in which supervisory and resolution authority may be found responsible according to the gross negligence model is not very different from the new trend in the liability regime based on the common law criterion of liability, because in that case authority are responsible for bad faith. We have an example in Ireland. We have an example, I think, in Malta. I don't remember if there are also other cases, but I think that the bad faith liability under a common law jurisdiction is sufficiently may also include the reluctances, and so may border the faute-lourde criterion and the French case law. I think that there is not this great distinction between the common law models on the one hand, the most important cases is the BCCI cases of the household law, no, the extension of the bad faith liability to the to cases of recklessness, and I think that this criterion could border the jurisprudence of the Conseil d'État on the gross border liability. So I don't think that there is such a big difference as the model may present. I think perhaps a very exception is the German one, because there is no liability at all towards depositor. This is the German and the Austrian one.
Thank you very much. Thank you very much, Raffaele, for these interventions. We are over time, which is excellent news because nobody noticed, unless those who need to leave. So I understand that you have other commitments. I wish to thank you very much. I think it was an extremely interesting discussion. For the audience, let me say that you understand that we didn't set up the questions. It was an open discussion, and we can discuss and agree and disagree on some points, but still it is obvious that there are a lot of outstanding issues. Let me give Diane the last opportunity to close this and give her my many thanks for having initiated this event.
No, thank you very much, Christos, and to the EBI for the opportunity to present this research, and to our three commentators today, Eleftheria Diamanti, Filippo Annunziata, and Seraina Grünewald, for the time and the insight. I think, it goes to show that we need to continue the discussion, and I also thank the Bank of Italy for always being open and supportive of all these initiatives. And with this, I wish everybody a nice afternoon, and thank you again.
Bye, and thank you very much to all those who attended.
Thank you very much.
Grazie a te. Ciao, ciao.
Grazie. Ciao.